And we are recording. Good morning.
Good morning, everyone, or good afternoon, whatever it is when you're listening. Welcome to this latest podcast. As usual, it's a chat between Managing Director of Practico, Andy Ellis, myself, a consultant to Practico, a retired cost silk, and our guest today, who we're not only pleased but also actually rather honoured to welcome, is Jamie Carpenter. I say we're honoured because he normally features in the front pages of the tabloid press. And so for him to come and speak to us is really something we're very pleased about. For those of you who haven't followed it or don't read the tabloid press, the Wagatha Christie trial has reached the world of costs as well now. And all I can say is it's quite interesting from the time I started doing costs, which was sometime in the last century, when cost was definitely the last thing for anyone to talk about and really was beneath everybody, that we now have leading silks who feature in the pages of the tabloid press in the discussions that they are having over costs. What a change the world has seen. So welcome, Jamie. Today we are going to be doing our usual thing of discussing anything from the general to the particular, not anything, but things from the general to the particular, focusing on collective proceedings in the CAT, particularly after PACAR and developments there, on budgeting, again, some strategic considerations arising in part from recent cases. The question of whether there is a future for something like mandatory ADR in costs. And finally, we will have a look at the career of the retiring senior cost judge, who was our guest, Practico's guest on the last podcast we did. And anyone who wants to see the very interesting chat we had with him will find it on the Practico website. But an appreciation by Jamie as a practitioner will also be very welcome. You'll have to be particularly careful about it because he and Andy are both going to a valedictory for the retiring senior cost judge, I think this afternoon. Anyway, welcome, Jamie. And if we could start by looking at the collective proceedings in the CAT post-PACAR and issues which have arisen there.
Yes, well, first of all, thanks very much, Andy and Jeremy, for having me back on. It's a delight to be back talking to you both again. Yes, it's something I think that no one would have predicted 10 years ago, that the Competition Appeal Tribunal would become, in many ways, the front line of developments in costs law. It was, I think, perceived as a sort of rather obscure forum full of barristers who divided their time between London and Luxembourg. But as a result of PACAR, which was, of course, originally a CAT case, it's really shot to prominence because of these collective proceedings that people are now bringing there and have been able to bring since 2015. And the reason why we're seeing this is that this is a rather unusual jurisdiction compared to what we're used to in civil litigation, where people come forwards to represent a class of people who have been wronged or alleged to have been wronged in a competition-related way. Whether that be, to use some of the examples we've seen, purchasers of mobility scooters or users of credit cards. And when they come before the tribunal, they ask to be certified as a class representative. And that process of certification involves not only looking to some extent at the substance of the claim and potentially its merits, but also the way they're going to fund the proceedings, because these people have to show that they've got funding to bring the claim. And also are going to be in a position to pay the defendant's costs if they are unsuccessful. And that means that the sort of agreements which are normally private to a litigant, such as litigation funding agreements and ATE policies, have to be made public, at least to a very significant extent, and are put under the microscope by defendants and the tribunal. And it was that process that resulted in PACAR in the first place. What actually ended up in the Supreme Court was a case about the prices of trucks that began in the CAT. And we're also now seeing the post-PACCAR manoeuvring playing out there. Specifically in relation to what was decided in PACCAR, what we're seeing are new arguments about what constitutes a DBA and whether the sort of different pricing mechanisms which funders have been putting into their LFAs after PACCAR in an attempt to avoid them being DBAs have actually been in that regard successful. And what we're seeing almost universally is that instead of the percentages, which we saw before PACCAR, or very often a greater of a multiple or a percentage, is just a pure multiple. What the funder stands to get is a multiple of the funding advanced, and that multiple very typically increases year on year or quarter on quarter over time. But crucially, for these arguments, what the funder actually gets at the end of the case is limited to what it receives through the payment waterfall when money comes in and it's distributed between the various people who have an interest in it, like lawyers for their success fees, AT insurers for their premiums, and the funder for its success fee. And there's a sort of non-recourse element to this, so that the actual funded party, the class representative, isn't left with any sort of personal liability to the funder that hasn't been recovered. And so defendants in these cases are now saying, aha, well, that is still a DBA, because what the funder gets is fundamentally still being limited by the recovery. So if you parse that through the language of Section 58 AA3 of the Courts and Legal Services Act, the amount of the payment, they say, is to be determined by reference to the amount of the financial benefit obtained in the proceedings. Now, we've seen, I think, 3 full judgments, some more full than others, but certainly at least 2 full judgments on that argument in the CAT, in cases called Alex Neil and Sony, commercial and interregional card claims, and MasterCard and Visa, and then lastly Kent and Apple. And that argument has failed every time it's been heard. What the tribunals essentially said is that there is a qualitative difference between something having an influence on what the funder gets paid and something being the substantive mechanism by which the funder's fee is arrived at. And what you have to do in each case is essentially look at the agreements and ask, look, what's the economic reality here? So in these multiples cases, what they're saying is, well, the determinant of the fee is the multiple. There happens to be a cap, but that is not what is substantively determining what the funder gets paid, so it's not a DBA. But they also say we can conceive of other circumstances, perhaps where the cap wasn't set as 100%, but was maybe 50% of recoveries, where actually the reality would be that is a payment which is being determined by reference to the recoveries, and so that might be the other side of the line. Where are we now on this? Well, those 3 cases are all on their way to the Court of Appeal. I don't know when they are going to be heard, and I've spoken to somebody involved in one of them who doesn't at the moment know either. The reason why we've had this hiatus is that, as you I'm sure will know, before the election, the government was proposing to retrospectively do away with PACCAR completely, and legislate it out of existence in a bill which was passing through Parliament when the election was called and died with the election. We have a new government now. These appeals were stayed for 3 months to see what the new government was going to do. That stay will, I guess, have very recently come to an end, but it doesn't look as if this is any sort of high priority for the government. There is a CJC report on litigation funding expected, I think, in July of next year, and it doesn't look as if anything's going to happen before then. So at some point, I think we can expect to see these arguments coming up to the Court of Appeal. What happens if the defendants win? What is this going to do to the state of litigation funding? Well, of course, you can avoid the argument completely just by removing the non-recourse elements of these arrangements. The argument depends entirely on the fact that you are capping the liability at what the funder gets back out of the recoveries. Remove that cap and you would have thought the argument would go away. And many of the entities that are bringing these collective proceedings are corporate SPVs. So potentially in those situations, that's a perfectly workable solution. Who cares if a shell company is left with an unenforceable liability at the end of the case? Of course, no private individual is ever going to enter into an arrangement like that. But you have to think that if these arrangements don't work, then there's really no obvious way you could structure an LFA with this sort of non-recourse element to avoid it being a DBA. And I'm sure that will be a central feature of argument in the Court of Appeal. There is also the question, well, does it matter if it's a DBA? Can't you just comply with the regulations? What's the problem there? There are a lot of people out there who think it's just not possible to comply with the DBA regulations with an LFA. I mean, they were obviously not drafted with funding agreements in mind. They're directed at lawyers. Could you thread your way through them? No court's had to look at that yet. But there's a particular problem with that in these competition cases, because most of them are what they call opt-out claims, where the claim is brought on behalf of all class members automatically, unless they choose, they actually make a decision to opt out of the proceedings and therefore not to benefit from them. And the legislation that governs all of this specifically provides that DBAs of any kind are not enforceable in opt-out proceedings. So if these funding arrangements are DBAs, whether or not you can comply with the legislation is neither here nor there. And it is very obviously going to cause serious difficulties for this jurisdiction. I think really it would be unrealistic to say anything other than these claims are not workable without funding, were that to be the case.
So then the question will be, does the government care about that? And is it the end of the world? I mean, views of third-party funding are not entirely on one side, although there's a very strong argument, obviously, for them being operable in order to enable this particular type of proceeding to work at all. And it's a type of proceeding that's clearly been envisaged by an Act of Parliament. But there are critics that say that the funders take too much money and there's nothing left at the end of the day. Do we have any idea, Andy as well, do we have any idea of what the government thinks about this, or has it been very silent on the topic so far?
I mean, my impression is that they are sort of taking the politically easy route of leaving the CJC to say whatever they say about it. But yes, certainly this is bringing the litigation funding industry under the microscope in a way that it hasn't been since the Jackson report. And of course, Sir Rupert was really quite relaxed about all of this. He saw no need for regulation other than the extent of self-regulation that there is through the Association of Litigation Funders, membership, of course, of which is entirely voluntary. But I think this time around, and particularly with the involvement of funding in these sorts of claims, I suspect there will be more of a call for some kind of external regulation and perhaps greater protections for people who enter into these sorts of funding agreements.
And I suppose the other thing is it's politically easy at the moment to leave it to the CJC. If the Court of Appeal were to find to reverse the decisions below, then there might be an urgency which couldn't be simply put off in the same way for the government.
I mean, that has to be right, I think, because of the damage that it would obviously do to these opt-out competition claims. I mean, any argument about whether those are to be encouraged or whether they are too redolent of the sort of class actions on the other side of the Atlantic that we're historically a bit sniffy about. I mean, that ship has sailed. These arguments were had then, and I think there's likely to be an acceptance that it has to be an effective jurisdiction, and it's not going to be an effective jurisdiction without some ability to fund these claims.
So in general, anyway, as a defendant facing a claim in the CAT, the first thing almost they reach for as a weapon is the cost argument, or almost over and above the merits or anything else to do with certification. Is that right?
Well, that is the way it's been heading recently, and things have taken a bit of a sort of further turn in that direction recently. There's been a sort of bit of up and down here, because when this jurisdiction was sort of first being explored, the indications were that the tribunal would look sort of quite closely at the merits, but wasn't going to be enormously interested in funding arguments. But once the Supreme Court got their hands on one of the early cases called Merrick's and MasterCard, the outcome of that was that essentially merits arguments, unless a claim was so bad that it was essentially strikeable at the certification stage, were not going to get defendants very far. And so when defendants are trying to look for ways to avoid the claim being certified at all, I think what they are principally alighting on now are arguments relating to funding. And a particular driver of this recently has been what seems to be an industry-wide change in funding terms in the last few years, which relate to the order in which people get paid. And so to make sense of this, we need to know sort of how these claims are supposed to work in terms of who gets what when they finish. If you're looking at an opt-out claim, what the tribunal doesn't do, in contrast to a traditional piece of commercial litigation, is take each class member and say, well, what have you lost? And they do it from a top-down approach of assessing what are called aggregate damages. So you just work out what the compensation for the entire class should be on the basis of sort of broad econometric considerations. And that gives rise to a pot of damages, which is then paid over to the class representative. And it's the class representative's job to encourage class members to come forward and claim their share. But although we may be talking about very large classes and therefore very large total amounts of money, often when these claims start, projections are for hundreds of millions and sometimes even billions. The amounts that any one class member might stand to recover are often very small. And human inertia being what it is, experience from other jurisdictions that have similar sort of arrangements, is that a large proportion of those class members, it might be perhaps 40%, won't come forward and claim their share. So these claims advance on an assumption, and it's assumption that Parliament shared when it enacted all of this legislation, that there will be a pot of what are called undistributed damages at the end. So there'll be a period, it might be 6 months, say, in which anyone who wants to come forward and claim their £50 or whatever it might be can do so. And then at the end of that 6 months, the shutters come down and you might have quite a large pot left over. At that point, the class representative can go to the tribunal and say, please, will you allow me to use this money to pay for things like success fees for lawyers, ATE premiums, and the funder success fee, which can't be recovered as inter partes costs. And I think it's fair to say that for a long time, the general understanding or assumption was that undistributed damages were the only way that those sorts of costs could be paid out, that the class members take their share first, and then there's a question of what's left over. It's different if there's a settlement, because if there's a settlement, the tribunal has to approve the settlement, and as part of the approval process, it will divvy it up and decide who gets what. But in a case that goes to trial and damages are awarded, it was generally assumed that class members go first, funders, lawyers, and insurers go last. Now that started to change in 2022 when we got a decision from the Court of Appeal in a case called Le Paturel and BT. And one of the questions that arose in that case was whether it was permissible, or might be permissible, the tribunal to order that distribution of the damages be by way of account credit. So if you've got a claim against BT, and let's say every single class member has or will have had a BT account, a pretty obvious way of distributing the damages would simply be to say to BT, well, pay each person's share directly into their account. if you do that, of course, necessarily you're going to have 100% distribution, and there's going to be nothing left for the funder and indeed the others who need there to be some undistributed damages in order to get paid. And the Court of Appeal in Le Pacharel said they couldn't see a problem with distribution by account credit. And then in passing, and completely obiter, because it wasn't an issue in the appeal, of course, if that was the case, then there would have to be some mechanism to allow the funder to be paid first, because without funding, these claims aren't going to get off the ground. Now, that suggestion in one case that there might be particular circumstances in which it might be appropriate for the funder to be paid first seems to have led to funders pretty quickly changing their terms so that class representatives had to seek the tribunal's permission to pay the funder in all circumstances. And it's very common now to see funding agreements where there is an express obligation on the class representative every time there is a recovery immediately to ask the tribunal for the funder to be paid out of that recovery. Now, this is really now, other than the question of what is a DBA, this is the real battleground that we're seeing in the CAB. And it's given rise to two questions in particular. I mean, firstly, can you do this at all under the legislation? Does the legislation even allow it? But even if it does, is it appropriate? Because you can immediately see the potential for this to give rise to conflicts of interest between the funder and the class members. And you can imagine a situation in which a claim succeeds, but the damages are nothing like what was expected, or maybe the class representative is forced because of the merits into a fairly low settlement. If the funder goes first, that is reducing what is left for the class members. In that situation, who should lose out, and how is it possible for the class representative to navigate those conflicts? They're contractually obliged to try to get the funder paid first, but their primary duty is to promote the interests of the class representative, the class members. So we've had one decision on this so far, which is a case called Gutman and Apple. That is again on its way to the Court of Appeal. It's got a hereby date in next March. The tribunal in that case were quite relaxed about this. They said the legislation does permit it and that it was appropriate because the tribunal could manage any conflicts of interest as part of its oversight role. So the tribunal always has to be asked to approve a settlement. The tribunal always has to be asked to approve any payment out to third parties such as funders. So they say, well, this is just another example of the kind of conflict that the tribunal can manage. Now, that was the position in Gutman. But more recently, there's been another case that I've been involved in called Reefer and Apple and Amazon, where I think it's fair to say we're waiting for judgment, but on the basis of how the argument went, the tribunal was instinctively not so relaxed about these issues as the tribunal in Gutman had been. And the way things have developed much further in that case is that the defendants, the proposed defendants, have sought to open up really every aspect of the process of securing funding to security, as well as the proposed class representatives' personal qualities and ability to discharge the duties that are placed on a class representative. And that actually resulted, uniquely as far as I can see, in my client actually having to give evidence and be cross-examined by two silks about every aspect of the funding arrangements, including minutiae such as whether the defendants had been correctly identified in the ATE policy schedule. And you can well imagine what a stressful and unpleasant experience that was for her. And what the defendants were trying to show was that my client was just not a suitable person to bring a claim like this. And in particular, they said because of her failure to grapple with the kinds of conflicts of interest that I've been describing, because the funding agreement in that case is one under which she is obliged, at least where it's appropriate, to seek to have the funder paid first. Now, as I said, we're waiting for judgment, so we don't know who in the end is going to be successful. But it does mark, even the way the hearing unfolded, marks quite a departure from previous tribunals' approaches to this issue. For example, commercial negotiations. In 2 previous decisions, the tribunal's been very clear that this is just not something which the tribunal should be getting into at the certification stage. If you have concerns about how much the funder is getting paid, for example, the time to address those is when you're actually asking for the funder to be paid, when there is a pot of money to pay the funder from. I don't think any proposed class representative has ever been grilled like this on their understanding of the funding arrangements and their responsibilities.
However that pans out, and obviously you can't say too much about it being involved, that potential is for a fairly heavy cross-examination of the class representative is there in all these cases with the funding arrangement you've decided, because you've described there is a potential conflict of interest built in, and really this is just the cross-examiner seeking to play upon that and to point out that the class representative is not suitable, when in fact who would be suitable if the problem is built into the arrangement?
Well, exactly. And of course, a major issue in these cases, and it was one in REFA, is also privilege, because class representatives necessarily rely on the advice which they get from the lawyers who are going to act for them. Do you say, well, I'm not going to answer questions about my understanding of these arrangements because that would require me to waive privilege, which, whilst of course legitimate, you can see from a perceptual point of view, perhaps doesn't look great. Or do you open up everything that you've been advised by your lawyers to the scrutiny of the tribunal? It's certainly, if that is the prospect ahead of anyone who puts their head above the parapet and agrees to front one of these claims, it's not going to make that a terribly attractive prospect. But then you can also say there are lessons for the funders here, because it's in the funders' interest to have these claims certified. I mean, they want to be involved in these because they see the potential for making a very healthy return on their investment. And it does show the dangers in trying to push the envelope of what might be regarded as acceptable and trying to hedge against every conceivable eventuality. You might well say that what the funder stands to gain from the anticipated level of success makes it perfectly fair that if the success is less than that, well, that's one of the risks the funder accepted when they took on the case.
Yeah. Andy, any thoughts on this round?
Well, no, very fascinating discussion, and I'm, obviously really interested in the fact that, as Jamie has said, the front line of litigation around these CAT proceedings is very much on the funding side. But inevitably, it will carry on. When we get past that, we're going to get into areas that we might have more to say about, if you like, or more input to. That could be security for cost applications, it could be budgeting, and in the end, somebody's going to have to work out whether the cost aspects of these at the end of the case, if they're successful, are reasonable. So we're waiting on the sidelines, but we keep a close eye on things.
Can I ask a very ignorant question of both of you? Have any of the proceedings actually concluded?
I'm aware of at least 2 which have concluded by way of settlement.
And people have been paid out?
Yes, I don't know whether the period for that has come to an end yet, but there was one relating to train fares and another one, I can't remember what that one was about. But this is relatively recent. Okay.
Of course, as a MasterCard, holder or ex-holder, I don't actually have an interest in this, because I gather that I'm not automatically opted in because I reside abroad. I'd have to actually opt in myself, which I haven't bothered to do.
That's right. Well, to claim the £4.50 that you might be entitled to in 5 years'
absolutely.
time. Yeah. No, that's very true, actually.
Anyway, look, that's fascinating. It is obviously a very dynamic area, and we just have to keep an eye on it. Another area which has been pretty dynamic, and again where strategy and tactics dictate a lot of the cost arguments, is budgeting. And I think there have been some developments there that you wanted to discuss.
Yes, so I was going to begin this with what might sound like the start of an off-color joke, asking the question, what do car exhausts and footballers' wives have in common? And the answer to that question is that they have both been responsible for some fairly important developments in our understanding of cost budgeting and the role of cost budgets on assessment. So this does give me the opportunity to talk a bit about the Vardy and Rooney case. But before that, I'm going to say something about the car exhaust side of things, and that is what is known as the NOx emissions litigation, or, to those who've been following this in more common parlance, Dieselgate, which is the allegation that manufacturers of diesel vehicles have been designing their cars so that they pass emissions tests when they need to, but don't then meet their emissions requirements when driven in the real world. Now, this is a quite extraordinarily enormous piece of litigation. In terms of the number of parties, people say it's going to be the largest piece of litigation ever brought in England. We've actually got 13 separate group litigation orders relating to different manufacturers, authorized dealers, finance companies. And they think that by the time all of those group registers close, there may be 1.5 million claimants. I think it would be impossible to find anybody who hasn't received several emails asking if they owned a diesel car during the relevant period and inviting them to sign up with one of the many firms that are bringing these claims. So the only way the court has been able to make these proceedings manageable is by having effectively a GLO of GLOs. So we've got 13 GLOs, and then within those, we've got 4 lead GLOs. And the way these issues, or some of them, are going to be resolved is we're going to have 3 trials of common issues. The first of those took place earlier this month, and that process is going to run up to late 2026. And everybody agreed that this litigation had to be budgeted. And we undertook the budgeting process for a good deal of that work in June. Again, just to give you a sense of the scale of the task, we had separate budgets for different parts of the proceedings. And then the claimants had to produce different budgets for each of those parts of the proceedings, directed at different levels of commonality of costs. So some budgets which were specific to a particular defendant, and other budgets which would contain costs that might be common to multiple claims. Now, the result of that was that at the budgeting hearing, we had 81 costs budgets to deal with and 3 days to deal with it in front of Mr. Justice Constable and the senior cost judge. And I think possibly the most astonishing aspect of all of this is that we actually managed it. We had a reserved judgment afterwards, but we got through everything we needed to get through in those 3 days, which is quite extraordinary. My involvement in it has been acting for Mercedes, which is one of the lead GLOs, and I have immediately to pause and pay tribute to the amazing work that Andy's team at Practico, who I was working with, did on the case. They did an incredible amount of work. They worked so hard, and everything they produced was so helpful and made my job so much easier. So I couldn't say any more about this case without paying proper tribute to them. And just to give you an idea of the numbers involved, I mean, if you just pick some adjectives out of the judgment, you can find eye-watering, extraordinary, staggering, and also frankly absurd. Though I do hasten to add that the more colourful of those adjectives were directed at the claimant's costs rather than the defendant's costs. But just to give you the numbers, across the cost that we were budgeting, which was going to take us up to spring of 2026, The claimants, and these are just common costs, of course, individual costs are a whole other matter that we weren't looking at. The claimants were seeking over £342 million in incurred and estimated costs, and the defendants between them were seeking just under £307 million. Now, those figures were reduced very substantially on both sides, though far more substantially on the claimant side. And we got a 30-page reserved judgment. And that judgment is incredibly useful as a rare illustration of how the courts will approach costs in a case of this size and complexity. And certainly I think the defendants will be feeling more satisfied with the outcome than the claimants were, because we managed to reduce the claimants' costs to about 25% of what they were claiming, while on our side, over the whole cohort, they were reduced to about 54%. Now, there are lots of things I could say about what's in the judgment, but I think given the time that we've got, I think I'll just pick out some highlights, if I may. An interesting tactical feature which emerges in a lot of budgeted cases, not just one of this size, is the claimant's costs were so vast that they really had almost no choice but to agree that the defendant's costs were reasonable, because they couldn't attack the defendant's costs without effectively attacking their own costs. Now, that gave the court some concern, because it thought that in many instances the claimants had agreed costs on the defendant's side, which were not, in fact, reasonable. And it was very clear in the hearing that the court wanted to be able to alter the defendant's figures, even where they were agreed. Now, in the unique circumstances of that case, the defendants did agree that the court could substitute alternative lower figures for figures which had in fact been agreed by the claimants. But where this is addressed in the judgment, we do see confirmation that in the ordinary case, that's not something the court ever has the power to do. If the claimant agrees, if one side agrees figures for the other side, which the court just doesn't like, the court's only choice, other than to let that through, is just to refuse to make a cost management order at all, and potentially to send the parties away to redo their budgets. But in this case, it was very clear that the court did not want to do that. And so the defendants agreed that the court could alter the figures in this case. There are also some interesting observations on how you approach the concept of proportionality in a case of that size. The claimant's valuation of the whole claims collectively was over £6 billion. Now, obviously, that is not accepted by the defendants, but even working with that figure, the courts took the costs which the claimants were predicting for this part of the case, thought that that probably represented about a third of the way through the entire proceedings. So scale that up to £1 billion of claimants' costs to recover, they say, £6 billion, and describe that as well within the foothills of disproportionality. And then they noted that the number of claimants actually has nothing to do with the level of common costs, because once you're trying common issues, it's irrelevant whether you're doing so on behalf of 20 claimants or 200,000 claimants. And so once they considered actually the real issues in these trials and their complexity, which was a good deal less than the claimants were asserting, then they were quite satisfied in the end that the sums in these budgets were wholly disproportionate.
Can you just remind me, what did anyone estimate the value to an individual claimant of success?
Figures of, I think, around £4,000 per claimant were being bandied around on the claimant's side. And indeed, 4,000 times 1.5 million claimants would get you to £6 billion.
The court was slightly dubious about that, I think, from the judgment. I mean,
well,
obviously they weren't going to express a view because they couldn't.
No. Well, there was a rather nice moment when we looked at a claim in some of the budgets for the cost of the solicitors buying cars from their clients, because the idea was where somebody's vehicle was selected to be a test vehicle, it had to be preserved, which meant for as long as the claim continued, the claimant couldn't be allowed to sell it. So it was decided that these lead firms would buy the cars from their own clients and then store them so they were available for the duration of the proceedings. And we were looking at where this unbroken down figure came from. And so the judge asked the claimant's counsel, so how do you calculate this figure? What does it work out per claimant? And they said, I think it was something like, oh, it's £12,000 per claimant, of course, being the foundation for a diminution value claim of £4,000. And so there was the Constable J's eyebrow certainly shot up at that point and said, I trust you'll be taking that into account in your calculations of quantum. So yes, I think it's fair to say the court was skeptical about that 6 billion valuation.
Yeah. Anyway, sorry, I interrupted.
No, well, the other points I think that come out of this that are quite important to note is that the courts are not going to accept submissions that, because litigation is enormous, the costs must be enormous, and there must be massive numbers of people working massive numbers of hours. And there's an important lesson in there that, even in the most gargantuan litigation, you still have to run it as efficiently as you can. So one of the lead firms had decided to man these claims by having separate sort of pods of people for each GLO working completely independently, basically duplicating all the same work. And it was one of the sort of the major aspects that we attacked in the hearing, and the court said, yeah, you can't do it like that. That's a completely inefficient way of running these claims. There are supposed to be economies of scale. There's supposed to be efficiency. The court was completely unimpressed by the idea. The claimant said, it shows how reasonable our costs are, that they're less than 5% more than the totality of the defendant's costs. And the court basically said, well, that's ridiculous. They should be far less than the defendant's costs, because you're doing everything once and they're all having to do it 13 times.
The thing of comparison of costs, you mentioned that as one of the issues in Knox litigation, but it came up in a rather different way, more tactically, in Vardy and Rooney, which is perhaps the legally more interesting part of the story, whereas I think the question of hotel bedrooms and things like that feature more in the tabloid press. Tell us about that.
Yes. To no one's enormous surprise, I guess, the press were more interested in whether Kaleem's solicitor was, to use my opponent's words, recreating scenes from Caligula in the Nobu Hotel, in the intricacies of completion of Precedent H, though I did really enjoy seeing a reporter live on the ITV 6 o'clock news talking about line-by-line assessment. And I like to think there's teenagers up and down the country are now putting costs lawyer on their school careers forms. But yes, to turn to the issues and why this is of interest to us costs boards. We had to debate the question of, are you allowed to deliberately lowball your incurred costs in your Precedent H? And was it misconduct to do so? And in particular, was it misconduct to do so, not tell anybody that you'd done so, and then come along to the cost management hearing and say to the judge, well, look at the outrageous costs on the other side. They're double hours. What on earth is going on? They're clearly running this case in a completely unreasonable way. You must comment adversely on their incurred costs and also reduce their estimated costs. And that is essentially exactly what the Rooney camp did here. It didn't actually...
in legal terms, that sort of breaks down into two things, doesn't it? What do you put in your schedule, your Precedent H, as incurred costs, and then do you then go on to make a comparison with the other side's costs? There seem to me two distinct issues there. The first of which is probably going to arise in every case because people always have that choice. The second one is a matter of a strategy.
That's absolutely right. And we argued about both of those. And yes, the first argument was, well, actually, what do the rules require? Or essentially, it's not the rules, because the only guidance on this comes from the wording of the statement of truth on a precedent H, which is actually, if you actually sort of try and parse it grammatically, doesn't really make sense. Because what it says is, this budget is a fair and accurate statement of incurred and estimated costs, which it would be reasonable and proportionate for my client to incur in this litigation. So our argument was, well, it would be is forward-looking. That's only talking about the estimated costs. You have to trim your estimated cost to be reasonable and proportionate, but you have to put in the whole of your incurred cost, and that's what you're certifying that you've done. Now, the senior cost judge didn't accept that argument. And in any event, because it's ambiguous, he said it was not going to be misconduct for someone to have taken the view that you could, or indeed should, limit your incurred cost to what was reasonable and proportionate. But of course, as you say, Jeremy, that's only stage one of the argument, because the question then is, well, when you've done that, can you then not tell anyone you've done that while throwing stones at the other side's budget? Now, here, actually, something which came up in Knox was brought into these proceedings, because there'd been a similar argument that the claimants had complained in Knox that some of the defendants who were using Magic Circle firms had put in their budgets on the basis of lower hourly rates than the clients had actually agreed to pay. And they said, well, that wasn't fair. And of course, the senior cost judge was one of the judges in Knox, and they had said, the judges there had said in the judgment, no, that's fine, providing there is transparency. And of course, you then do have to be careful about making comparisons, but that's even where there is transparency, you have to be careful about that. Now, there was no transparency in Vardy and Rooney. But the judge said there wasn't misconduct. And the way he reasoned that was to say, well, if it's reasonable to take the view that you are required to limit your incurred costs in precedent H to what's reasonable and proportionate, then you might also assume that your opponent had done the same. Now, even after that, though, he went on to say that he was nevertheless critical of Rooney's lawyers for not being transparent about what they had done. And as he put it, if your declared costs are X and your opponent's are 2X, but yours are really 2X, you can't have a go at theirs for being 2X without revealing that yours are 2X. So far, so good, we thought. But he ended up concluding, and in his own words, only just, that there wasn't misconduct because of this ambiguity in the wording of the statement of truth, and the possibility that the solicitor would have assumed that actually on our side we were doing the same thing. Yeah.
Oh well, nice fudge, which saved the day, if you like.
I mean, it did for now. I think I'm not giving away anything by saying that by the time this comes out, I think an appeal against that decision will be in train. So hopefully we will get to have these arguments again, and we'll see what comes out of them.
You're just seeking more publicity for yourself, Jamie.
There's got to be another front page in it, Jeremy.
Very quick touch upon Master MacLeod, who's retired, I think, now, and her comments about ADR in costs in the case of Elphick and the Times.
Yes, well, I won't say anything about the substantive decision, but there is an interesting postscript whereby she required the parties to engage in some form of cost ADR, which she thought should be a mediation, before detailed assessment was commenced, and she would extend the time for doing so until after a mediation had taken place. And she thought that orders like that should be the norm. I mean, I have to say, I totally understand the motivation. But I do think, with respect to her, that her approach to this may well have been driven by an experience of sitting as a deputy cost judge, which she herself referred to some time ago, and which I think is probably now rather out of date. And she talked about it being unsatisfactory that you get court door settlements when everybody has incurred the costs of detailed assessment, or that you get settlements after determination of preliminary issues, and there ought to be mechanisms to really crystallize all of this at a far earlier stage. But I think as the rules stand, there's a rather fundamental difficulty with what she was proposing, which is that there is no mechanism, unlike with substantive litigation, where you have all these pre-action protocols. There's no mechanism, no formal mechanism in cost disputes for doing anything prior to the commencement of detailed assessment. The only step that's provided for in the rules is the production of a formal bill of cost, and then after that, points of dispute, and so on. And before that, the amount of information available about the cost claim is entirely in the gift of the receiving party. And of course, the receiving party that knows they may have some problems or the things they want to fudge is going to find it very easy to do so. And a mediation or any other form of dispute resolution based on the sort of level of information that you're going to get from what might be provided, for example, when seeking a payment on account, is, I think, not going to be terribly effective. I'm also not sure that it's really, in most cases, going to be at all necessary, because most costs cases are going to be budgeted, or they're going to involve fixed costs. And there's a huge amount less scope for dispute in those cases in any event.
It's also, as you say, I mean, quite hard to mediate or do another form of ADR without at least a proper bill, which prevents the receiving party from keeping to themselves the bits they don't want to be frank about, and gives a certain amount of transparency to the other side to see what's being claimed. I mean, I seem to remember, and you'll correct me if I'm wrong, a case which had been very complicated, where quite recently the receiving party said, can't we have, we don't have to produce a bill, we'll have a assessment proceeding starting so we can deal with preliminary issues, but we don't want to produce a bill till all that's been done, and you can direct cost judge what we need to do in our bill. And that was rejected as unacceptable. You probably have, I'm probably completely wrong, but you might remember what I'm talking about. You don't remember, so that's right. It's probably.
I can't immediately think of a particular case, I'm afraid.
Anyway, look, that's been fascinating on the things that are going on today, and the as ever, costs being at the forefront of the battle between people who have or have not won their claims. Just one last thing, bearing in mind you're going to evaluate this afternoon, would be just a look over the period in office, if I can put it that way, of Master Gordon Saker, a senior cost judge, following on, of course, from the very long tenure of Master Hurst. Anything particular that strikes you? You don't have to be incredibly polite or incredibly rude, but just other aspects of his rule that strike you.
Well, I think I'm certainly not going to have the temerity to pass judgment on his tenure as senior cost judge. But speaking as an advocate who's appeared before him many times, I think the first thing you'd have to say is that what a pleasure it always was and has been to appear in front of me, in front of him. I mean, if you wanted to see the personification of affability, it would have to be Andrew Gordon Saker. I think the most extreme reaction I've ever managed to provoke from him is a raised eyebrow. He's certainly overseen a period of a lot of change inside and outside the SECO. I mean, just in terms of the making up of the cohort of cost judges, there's been an almost complete changing of the guard. And I had a look the other day at who was in post at the time he became senior cost judge, and it was only cost judges Leonard and Rowley, other than him, who were there then, who are still there now. But I think if I'm going to look for sort of a real success of his tenure, I think it would probably be the SCCO's ability to move to electronic working, and particularly the way it dealt with matters during the pandemic, and the really extraordinarily seamless way they moved straight into having remote hearings, and moving away from the days of cost judges' rooms being full of boxes and boxes of paper. And indeed, I can't remember actually the last assessment that I did where the solicitor's papers were lodged in hard copy rather than PDFs. I mean, of course, we were always going to head in that direction with the introduction of e-bills, but I think actually the speed with which we've moved to almost universal electronic working has been really impressive, and has certainly made carrying out assessments a lot easier and a lot more efficient.
Certainly from what I've seen as an outsider by this stage in all of that, you might say, well, the move towards virtual working was inevitable always, but it certainly wasn't, and the court system has never been very good at developing IT systems. And to have done this in the pandemic with such success, and I think to universal acclaim, was really a remarkable achievement.
No, I mean, that's absolutely right. I mean, if on the other hand, I was to sort of look for anything that Andrew might regret about his time in office, I think the obvious candidate would be that the fees-related parts of the Solicitors Act are in as rude health when he leaves office as when he took it. And he certainly made no secret of the fact that he regards Section 70 as an anachronism. And I remember very soon after his appointment, he came to give one of our annual costs lectures in Hailsham, and he said then that he had Section 70 in his sights. In fairness to him, I think Brexit and COVID, to name but two things, and there have been plenty more, will have conspired to push any reform of the Solicitors Act down the legislative agenda. I think I also have to say, as somebody with a mortgage to pay, I'm not personally too sorry about it.
Yeah, absolutely. Well, I love the Solicitors Act. I would be very sorry to see it go. One had some wonderful arguments. But it's also probably right to say that it's going to have to wait for a government with very little else to do to bother to get into the minutiae of the Solicitors Act, because it's really not. It's not a vote winner, and it's not a matter of interest to most people.
No. But it's also, I mean, there is also some judicial development here. I mean, we don't have time to talk about it now, but increasingly, the parts that might be regarded as anachronistic and are being sort of removed by decisions about what are bills and when can bills be delivered. So that's doing something at least. Right.
Well, look, Jamie, as ever, thank you very much. It's been a very illuminating discussion. I'm sure Andy will join me in sharing our thanks to you for this. And I wish you both a very pleasant afternoon at the valedictory in what will no doubt be a very crowded courtroom.
Yeah, well, thanks again for having me on. Nice to see you.
Thank you. Thank you very much, Jamie.